everyone. My name is Salima Siddiqui, and I'm the project coordinator at Health Nexus. I'd like to just speak about Health Nexus and what we do here. Health Nexus oversees several provincial initiatives related to FASD, the FASD provincial website, where you can find recent and up-to-date information about what's happening, learn more about resources and tools, and find out services available in your local community. We also allocate subsidies every year to 40+ support groups for individuals with FASD and their families. And we designed an online training for service providers from various sectors, including healthcare and nursing, education, mental health and addictions, justice and corrections, and community and social work. Before we begin, I'd like to just start off with the land acknowledgement. We would like to begin by acknowledging the Indigenous peoples of all the lands that we are on today. While we meet today on a virtual platform, let's take a moment to acknowledge the importance of the lands which we each call home. We do this to reaffirm our commitment and responsibility in improving relationships between nations and to improving our own understanding of local Indigenous people and their cultures. From coast to coast, we acknowledge the ancestral and unceded territory of all the Inuit, Métis, and First Nations people that call this land home. Please join me in a moment of reflection to acknowledge the harms and mistakes of the past and to consider how we can each, in our own way, try to move forward in a spirit of reconciliation and collaboration. Before we begin, I would like just to go over a couple of house rules. During the presentation, you may be tempted to ask questions at the end about yourself or loved ones with FASD. Please do not use any identifying information to protect people's privacy. By law, we have a duty to report to Children's Aid Society or the police any threat to a child or a direct attempt to harm yourself or someone else. Presenters cannot provide clinical advice, as this would require professional counseling and more in-depth knowledge of the situation and behaviors at stake. Today's discussion provides information about latest research, evidence-based practice, or general education tips and advice. If you need ongoing support, please consider connecting with your local FASD worker for supports or join one of our Health Nexus support groups for individuals with FASD and their families. You can find this information on our website, fasdinfotisaf.ca. And also please remember to stay off mute kindly during the presentation, and please keep off camera during the presentation as well. We will have a designated Q&A section at the end of the presentation. So if you do have any questions, we will ask them during that time. And after questions have been answered, we will take a few minutes to network and chat about group updates. And that's when you can turn on your cameras and turn on your microphones as well. So I want to introduce our speaker, Natalie. Natalie is a partner at the law firm of Natalie Sanna Estate Law. The boutique law firm offers services exclusively in the areas of wills and estates, trusts, and real estate. She's dedicated to helping clients and their loved ones plan for and deal with disabilities, incapacity, illness, and death. From the beginning of her law career, she has been drawn to the areas of wills, estates, trusts, and guardianship, as it allows her to serve her clients and their families on a personal level and develop lasting relationships. Natalie has always called the Ottawa area home, growing up in a small village just outside of the city. She obtained a Bachelor of Arts honors degree in psychology from Carleton University. Her studies continued at the University of Ottawa, where she completed her law degree. She articled at a mid-sized firm in Ottawa. Her law career has been somewhat atypical. Following her call to the Ontario Bar in 2003, she began practicing in the areas of wills, estates, and trusts with Donna Neff. Following the birth of her first child in 2006, she continued to be an integral part of the firm, always fully immersed in the areas of wills, estates, and trusts, while juggling the joys of parenthood. In September 2016, she was thrilled to return to the practice of law. We are thrilled to listen to her presentation today. Please ask your questions in the Q&A in the chat, and I'll provide more information and links in the chat as well if need be. I'll pass it on to you now, Natalie.
Thank you very much. I'm so excited to be here with all of you today. Thank you for taking a little bit out of your afternoon to be with us. So today I'm going to touch on a very broad overview of some estate planning concepts that may be of interest. We'll talk about wills, Henson trusts in particular, and then a little bit about substitute decision making. So I'm going to throw a lot of information at you in a short amount of time. I apologize for that, but my hope is always that maybe I touch upon a thing or two that may resonate with you and that you take back to your own advisors to explore in more depth in case it's relevant to your situation. All right, so to begin with, I want to share the point that every capable adult needs a will. So I'm directing this presentation at yourselves as parents or loved ones with a beneficiary or a child with FASD, as well as the FSD individual themselves. Every capable adult should have a will. We often hear people say, well, my situation is very simple. I don't even have anything. Well, everyone has something, a little something, even if it's just a bank account and an online account like Facebook, and everyone files taxes. So having a will can make the job of dealing with such things following a death much easier for loved ones left behind. But having a will is especially important if you have minor children, a child with a disability, common law spouse, anything that you may think is not so simple. Now, when I say I would want everyone to have a will, what I'm really actually saying is I would like everyone to do proper estate planning. And what I mean by that, estate planning, in contrast to simply signing a will, estate planning is really having a look at what your assets are, how you hold them, how they're going to flow on death, and a comprehensive overview of your particular and unique family situation. Estate planning should be proper, and that's what I mean by that, is that it should be comprehensive. The lawyer you're working with should ask you a myriad of questions covering everything from assets, who you want your executors to be, where you would like things to go, as well as, details about your beneficiaries, so that all of the options can be explored. For example, trusts of some kind to provide for a certain beneficiary in a specific way. Your estate plan at the end of the day should be tailored to your unique situation. It shouldn't be a fill in the blanks exercise, or what I've said here, a cookie cutter approach. You're unique, and although it may sound cliche, your estate plan at the end of the day should be unique as well. Now, you might have noted that I said every capable adult should have a will. And what I mean by that is that in order for someone to sign a will, they need to have the mental ability or mental capacity to sign that will. And that capacity is actually a specific legal test that is set out in the law. It's not set out in the written law, but it is developed over time in the cases that have come before judges. So it's not a clinical diagnosis by a psychologist or psychiatrist. Someone could be diagnosed with a certain mental illness and still have the capacity to sign a will. It's more an evaluation of the person's ability to understand and appreciate the information and decisions that have to be made when making a will. And it is relevant to the person's own circumstances and life experience. I've set out the test there in the slide, so you can have a little bit of appreciation of what exactly sorts of things are explored. And generally, such capacity can be assessed by a formal capacity assessment by a professional assessor who's certified and qualified under the relevant legislation, but it's also done by lawyers, in that we have a professional obligation to ensure that every client who we have sign a will does have the testamentary capacity to sign that document. And I really couldn't talk about estate planning in any way without touching on probate a little bit, just to give you a quick idea of what it is, because we all have heard the term, but many aren't exactly sure what we're referring to. So probate is actually a court application by which the court confirms that the will before them is indeed the last signed original will of the deceased, and that the executors named in that document have the authority to act. So essentially the court's blessing or confirming that, yes, this is the last will of the deceased. And then others can rely on that document that's issued by the court. Now, of course, the government has attached a tax to this process that we're all familiar with. And how it's calculated based on the value of the assets that pass into the estate. The first 50,000 of estate value attracts no probate. But then it's $15 per thousand after that with no upper limit. So unfortunately, we do have some of the highest probate fees in the country. Now, we don't need to probate every will. It depends on what assets the deceased owned and passed into the estate. So where the deceased owned real property in their sole name, we generally have to probate in order to deal with that real property. Absent real property, it will be up to the financial institutions who are holding the deceased's accounts as to whether they're going to require the executors to go off and get the probate certificate from the court before they're willing to pass the deceased assets to the executor. So from the bank's perspective, it's a matter of risk. They want to satisfy themselves that they are passing those assets to the right executor, and another person's not going to walk through the door with another will signed by the deceased, and lo and behold, the bank's paid the deceased assets to the wrong executor. So what assets are probated, as I mentioned, are those that pass into the estate. So those would be assets in the sole name of the deceased that don't have a beneficiary designation and aren't jointly held with anyone else. So because, as all things where taxes are involved, of course, we have developed ways to avoid probate fees in certain circumstances. It is actually possible for someone to sign not one, but two wills, and pass certain assets through a secondary will in order to avoid probate fees. The main assets we can pass using this option are shares of a Canadian-controlled privately held corporation, but we can also pass household goods this way. So sometimes the probate savings are significant enough on our household goods and vehicles, think a book collection or antiques, that we will do up a secondary will just to deal with these household goods. We can also name beneficiaries on certain assets like TFSAs or life insurance. And when we've done that, those assets pass directly to the named beneficiaries and don't form part of the estate. Also, joint ownership can ensure that an asset flows to a joint owner without going through the probate process. Now, our philosophy at our firm, however, is yes, we do need to explore probate savings options where we can, but we shouldn't narrowly focus on probate savings because there's some other more significant estate planning goals that sometimes result in probate fees having to be paid. And the most important of which, I would argue, are Henson trusts, which we're going to talk about further. But at this point, I just want to say, in order for funds to get into the Henson trust that we've included in our will, the assets must first pass into the estate. So sometimes that means paying probate fees. So the takeaway would be, don't narrowly focus on saving probate fees, but make sure that it makes sense in your overall estate plan. So before I dive into Henson trusts, I just want to touch upon trusts a little bit in general, because I can appreciate they're kind of confusing concepts. We've all heard the term, but what is a trust exactly? Well, actually, it's simply a relationship that is created in the law. It's actually a triangular relationship, as there's three main parties involved. There's the settlor, or in the case of a Henson trust included in a will, that would be the testator or the will maker. That's the person who creates the trust. We then have the beneficiary, the person who is going to benefit from this trust. And then lastly, we have our trustees, who are the people who are entrusted with the management of the trust. So this is, generally speaking, a Henson trust is included in the will of someone, and it doesn't take effect, or it doesn't come to life, for lack of a better description, until the will maker, the testator, has passed away. And at that time, when we have a distribution ready to go to that beneficiary for whom the trust is created, we will fund the trust and begin its management. Now, I've said it's a relationship, a trust is a relationship, legally speaking, but on the tax side of things, it's been decided that a trust is going to be a separate taxpayer. So one of the jobs of a trustee is to file a separate income tax return in which gets reported all of the income or interest that the trust assets have earned. Now, a particular type of trust that's of interest to us today is what's commonly referred to as a Henson trust. Now, just if you're having a look at your will and wondering if you do indeed have a Henson trust, you might not necessarily see the word Henson, so don't panic if you don't see it. That's just the name of the family that took this issue to court, but its more formal name is an absolute discretionary trust. And that's because what's so special about these trusts is that the trustee, the person in charge of managing the trust, has complete discretion with regard to what payments are made from the trust. So they can make payments at any time and in any amount to or for the benefit of the beneficiary. And that's contrasted to another type of trust where we might have specific payments that have to be made, like i.e. you pay $10,000 must be paid each year to a beneficiary. We don't have that with a Henson trust. And it's because of that discretionary nature of the trust that when the court in the Henson matter, when it came before them, decided that ODSP could not consider a Henson trust to be an asset of the beneficiary because they have no control over when and how and if payments are actually made to them. So as a result of that case, a Henson trust is not considered to be an asset of the ODSP recipient. So an ODSP recipient can have one or more Henson trusts with any amount of money in them, and it will not affect their ODSP benefits. Payments from the trust, however, must be made in accordance with ODSP's rules. So currently a beneficiary could receive $10,000 in a 12-month period, in addition to any amounts that are needed for disability-related payments or education-related expenses. So there's no asset limit as to how much you can have in a Henson trust. And it's also interesting that a trust can hold a range of assets just like an individual. So the trust funds can be invested in stocks or bonds or GICs. It can have a bank account. It can also hold real property. And this in particular might be something you bring back to your advisor to discuss. If providing a residence or a real property for your loved one to live in after your death is part of your plan, then it's often a good strategy to consider flowing that real property or including the ability of your trustee to purchase a real property using the trust funds and hold that real property as an asset of the trust. What's nice about it is that any expenses that are then needed for the maintenance or repair of that real property come out of the trust funds. We don't, for example, it's certainly allowable for an ODSP recipient to own a home, but the problem becomes if that home needs a new roof, for example, and we need to take funds out of the Henson trust to pay to the ODSP recipient to then use to fix the roof, that counts towards the $10,000 that they can receive. Whereas if the trust owns the real property, the other trust assets can be used for any repairs or maintenance without having to flow those funds through the beneficiary's hands. So it can be a real neat planning option that's available. One of the biggest and often most difficult decisions for a parent creating a Henson trust in their will is who to appoint as the trustee. As I mentioned, the duty of the trustee is to manage the assets in the trust. They are held to a very high standard under the law because they are managing assets on behalf of someone else. They do have a duty to maintain accurate, up-to-date records and to file and pay income taxes, as I mentioned. Generally, the will containing the Henson Trust will also allow the trustee to take compensation, and that's something you should turn your mind towards as to, what your intentions are in that respect. Under the law, generally, an executor as well as a trustee can take 2.5% of the monies they receive under their care in their role as trustee or executor, as well as 2.5% of the monies that flow out of their hands as trustee or executor. So their compensation is calculated based on the flow of monies passing in and out of their hands. The 2.5% is what's generally allowed under the law, but the testator or will maker can include whatever provision they want in their wills as to the amount an executor or trustee could take, as well as they can say they don't want their trustees to take any compensation whatsoever. So I mentioned that the trustee of a Henson trust has absolute discretion with respect to making payments from the trust. And a result of that, choosing a trustee is of key importance because they're going to have a great deal of authority. So obviously you want to choose someone who's very trustworthy. And I also think it's very important to choose someone who will take the time to get to know the beneficiary and understand their needs so that the trust can be properly managed for their benefit. And it's also important that they take the time to become familiar with ODSPs rules so that payments from the trust aren't made in contravention of those rules. Now I know, I wanted to say one thing before I move on to that. So just a little bit about the duties of an executor as well. The executor is responsible for the administration of the estate. So generally speaking, the executor will do their job first, and then at a point where they're able or to make a distribution from the estate, at that point, the duty of the trustee will begin. Now, your executor and trustee can be the same people. And in fact, they are the same people if you don't say otherwise in your will. So if you've said, okay, my cousin Jim is to act as my executor, if you don't say otherwise, Jim would then go on to be the trustee of the trust as well. Or you can appoint executors and then say in your will, well, when the job of the executor is done and they're ready to fund the trust, then I want, this person to take on the role of trustee. So we always advise people to discuss with their proposed executors and trustees to make sure they're willing to take on the job. An executor or trustee, even though they're appointed, they can turn down the job, for lack of a better description. They don't have to take it on. So before appointing and thinking that you have the peace of mind and having people in place to do the job, it's important that they're on board. And then best advice is to make sure that you have all of your asset information, contact information for the professionals that you work with, all in one place so that your executors and trustees will have easy access to this information and won't have to spend time and energy in trying to track down all your assets and figure these things out for themselves. Ideally, an executor and trustee will work with a lawyer, a financial advisor, and a tax professional to support them in their roles. And with those three professionals in place, they can be well equipped to manage the duties and responsibilities that come with these roles. Now, I do know that working with many families, it is often difficult to have people in our lives who are able and or willing to take on the role of executor or trustee, especially the role of trustee. It can go on literally for decades. And then ideally, we do want, best case scenario is that you'd have a series of alternates appointed so that if person A isn't able to act for whatever reason, person B is there to step in and take up the role. There are available, some people aren't aware, so I like to mention, there are professional trustees and executors able to do the job. Each of the major banks has a trust company component that will take on these appointments. And the nice thing about that is that you have some comfort in knowing that the institution's going to be around for a long time to do the job and that they will perform the job up to the highest standard. And then, oh, I should point out that you can appoint more than one person in each of the roles, which is often a nice way to go, just to give, then they can split the roles between them. And sometimes it works out well if you have one person who is very familiar with the beneficiary and another person who's maybe, very well organized and has some experience, investing or something along those lines. That's a nice combination of personalities to have in the role of trustee, if possible. I'm going to switch gears a little bit and turn to substitute decision making for the final bit. So, as some of you probably know, if your loved ones are already over the age of 18, but when a child turns 18, they are presumed capable under the law, and any parental authority to make decisions on behalf of a child ends. So then we want to turn our minds to, if my child, my loved one, ever needs a substitute decision maker, how do I get myself appointed in that role so that I have the authority to continue making decisions for them? So as I mentioned, it's important to note that under the law, the starting presumption is always that a person has the mental capacity to make decisions for themselves. So all of us can rely on that presumption, unless there are reasonable grounds to believe that they don't have that capacity for some reason. Now, when I'm talking about mental capacity, I touched on it a little bit with testamentary capacity, but I mentioned that it's a legal construct and not a clinical diagnosis. So someone could have been diagnosed with bipolar disease or dementia and still be mentally capable of doing a certain thing. I say doing a certain thing because mental capacity is actually decision or issue specific. So there's, as you saw, there's a particular test of mental capacity to sign a will. There's a different test of mental capacity to sign a power of attorney, a different test of mental capacity to be able to manage one's finances. And that's because we don't want mental capacity to be a global assessment that somebody loses all the rights to make their decisions. That's meant to be a very last resort. We want to focus on what a person is capable of doing, and perhaps then they're maybe incapable of making a certain decision or doing a specific thing. So if someone is deemed not mentally capable of doing a certain thing, then their right to make their own decisions in that regard might be removed. And then a result of that is that there could be someone who's then entitled to step into their shoes and make that decision on their behalf. So then we have our substitute decision makers. And in the law, we've essentially divided up any decision a person can make into one of two categories. It either has to do with property, not just real property, our assets, our finances, or our personal care. So anything to do with our person. And on the property side of things, the different substitute decision makers we can have are a power of attorney, guardians, one of two kinds, statutory or court appointed. And then we have some informal trusteeships. Some of you might be familiar with those. For example, ODSP allows a trustee to receive ODSP benefits on behalf of an individual and manage those ODSP benefits on their behalf. On the court-appointed side, on the personal care side of thing, we have a power of attorney for personal care, as well as a court-appointed guardian. So a power of attorney for property is, again, a document which every capable adult over the age of 18 should have. I should note that powers of attorney are in effect while you're living, and the authority of an attorney ends on your death, at which time the authority of the executor would come into play. Now, don't be confused by the term attorney. It was a very poor choice of terminology by the government when they enacted these laws. Attorney in Ontario means substitute decision maker. So when someone signs a power of attorney for property, they are picking someone to step into their shoes and make decisions for them with respect to their property. Now, generally speaking, we make our power of attorney for property documents very broad in that the appointed attorney can do anything that the grantor or the individual who signs the document can do, except make or change their will. You can include conditions or restrictions in the document, but generally speaking, if we need someone to act as our attorney for property for us, we want them to be able to do anything that we can do. Now, in order to have the capacity to sign a power of attorney for property, it's a specific test that's set out in a piece of legislation called the Substitute Decisions Act. Generally speaking, often whether a person has capacity or not often turns on the first point, and that is having an awareness and an understanding about what one owns and the value of those assets. Now, this test is context specific to the individual themselves. So someone who's capable wouldn't fail that capacity simply because they don't understand the stock market if the stock market's not something they've ever participated in. They, for an ODSP recipient, for example, as long as they can speak to the benefits they receive, the bank account where the money goes, maybe they have an RDSP, and be able to speak, as to how they spend their money and what they like to spend their money on and how much they spend for their expenses. That is how the test is meant to be applied. Now, it's also important to consider what happens if my loved one hasn't signed a power of attorney for property or was not capable of signing a power of attorney for property, and they're not capable of managing their property. Then we look to the informal trusteeships. And because of these trusteeships, it's generally true that parents who have a child with a disability don't need to apply for guardianship because they're able to manage the adult child's assets through informal trusteeships. Where there are assets outside of these informal trusteeships that need to be managed or issues that need to be dealt with, and parents or other loved ones don't have the authority to act on behalf of the adult child, then we do have to look to a court-appointed guardianship. So it's an application to court whereby we have to satisfy the judge that the individual doesn't have the capacity to manage their property and there is a need for a guardian. So we can't go to court with the thinking that, well, I just want to make sure that everything's in place should something happen to me. I want to make sure, someone's in place to assist my adult child. Unfortunately, our system's a little bit more reactive than that. We have to approach the court with an actual issue that needs taking care of, but can't be taken care of because there's no one with the authority to act on behalf of the incapable person. And on the personal care side of things, we have our power of attorney for personal care. Personal care decisions have anything to do with our person, like I mentioned, food, clothing, shelter, hygiene. And then, of course, the most significant decisions would be the consent to treatment decisions. Now, mental capacity is also dynamic in nature, for lack of a better word. So it can fluctuate throughout the day. You can be capable of some decisions, but not others. For example, think of someone who's perhaps in early stages of dementia. They might be perfectly capable of deciding what to eat and wear on a given day, but they meet with their doctor. Doctor needs consent to a treatment, doesn't feel the individual's capable of maybe that complex a decision. So at that time, turns to the power of attorney to make the decision for them. So our power of attorney for personal care, never acts for us unless we are incapable of making a particular decision. Our power of attorney for property, on the other hand, can act for us if we're perfectly capable, but if we instruct them to. So that's the big difference between the documents. Think of someone later in life, maybe not so mobile, maybe challenged by online banking. They may be perfectly capable of managing their own property, but turn to their power of attorney to take on certain tasks that they simply don't want to do or would just like to be taken care of by someone else. So the legal test of mental capacity for signing a power of attorney for personal care is quite low. The individual just has to understand that the person they're appointing or be able to confirm that that person in their minds would have a genuine concern for their health and welfare, and then appreciate or understand that the person they're naming may have to make a personal care decision for them. If someone doesn't have a signed power of attorney for personal care and they've become incapable of making their personal care decisions, then a court order for guardianship of the person can be sought. But there is some coverage in the Healthcare Consent Act. So the Healthcare Consent Act covers consent to treatment decisions. So if we were in hospital, and our doctor needed consent to treatment decision, but we didn't have capacity, they would turn to the Healthcare Consent Act to determine who they should have that decision made by. At the top of the list is a court-appointed guardian or power of attorney for property. But if the individual doesn't have either of those, then the doctor's to ask spouse, then children, then parents, then siblings. So the doctor goes down through the list until they have someone available to make that consent to treatment on behalf of the individual. Now, this is a little bit out of place, and I apologize, I've just popped this in at the end, but I always get questions on this, and there is often confusion surrounding RDSPs and what happens to a loved one's RDSP if we've passed away. So it's important to know that any monies in the RDSP, if you're a parent, for example, and you're the plan holder, or you've contributed to an RDSP on behalf of a child, the RDSP will never form part of your estate. So you can't deal with it in your will. The RDSP always stays with the beneficiary or the adult child. So if they were to pass away, the RDSP becomes part of their estate. All the more reason that if they're over the age of 18 and capable, they have their own will, so they can direct where this asset and anything else they own goes. If they're not capable of signing a will, then it would be distributed according to the intestacy laws of Ontario. Just like with the Healthcare Consent Act, there's a list of people that it goes to, generally family. So I know there's a misconception that the government gets their fair share, but the government only gets a portion. Well, the government would receive the estate if truly the individual had no family. And another thing I like to mention, we like to include a provision in our power of attorney for property for parents who contribute to an RDSP on behalf of a child. We like to include a provision to allow those contributions to be made by a power of attorney. It would be questionable whether an attorney would be able to make such a contribution without specific authority to do that. And another issue that arises with RDSPs, or a potential issue, is that, as many of you may know, under the legislation, a parent can be a plan holder of an RDSP on behalf of an adult child. But unfortunately, the legislation doesn't contemplate any other family members stepping into that role. So the concern is that when parents pass away, if their child is not able to sign their own powers of attorney and appoint a substitute decision maker for themselves, and they're not able to manage the RDSP on their own, there isn't going to be anyone available to manage the RDSP, and someone may have to make an application to court for guardianship in order to continue the management of the RDSP. Now, we are told that they are looking at allowing siblings or potentially other family members to also be plan holders. So that's a change we're hoping to see in future. All right, so I think we're going to take questions, Halima?
Thank you so much. Everyone, please feel free to put your questions in the chat and I can read them out for Natalie to answer. We already do have a couple questions here, which I can start with. So first, if we decide to hire a company to be the executor of our will and or trust, can we set it up so the company has to accept advice from a named family member? Can you name an individual and a company to be your executor and or trustee?
Yes, most trust companies will accept joint appointments. Now, the best procedure when appointing a trust company is to work with them at the outset, and then they will then you will bring in your lawyer who will draft documents, and the trust company often likes to review the documents before they're signed. But yes, I have done joint appointments for most of the major trust companies, and it is possible to build in clauses that direct the trustees to take advice from a loved one, a friend, whomever. Again, that's something you'd want to discuss with the trust company. It may be something that's included right in the will, or maybe it's done in a memo as guidance to the trustee.
Thank you so much. Someone's asking, can you speak to the circumstances that typically lead to a capacity assessment being undertaken to determine whether an individual requires a substitute decision maker?
So it usually, that's a tricky one. So now I'm assuming you're not talking about the drafting of documents, but maybe I'll touch on that first. So generally speaking, the best case is to have the individual meet with a lawyer who will make an assessment in their opinion as to whether the individual has capacity, whether or not to sign powers of attorney and a will. If the lawyer is in doubt, at that point, it might be recommended that a capacity assessment is done to see if they can execute these documents. Now, if you're talking about a capacity assessment as to knowing when to step in as a power of attorney for property, that can be very tricky. And it'll depend on what the power of attorney document says, but just assuming it says it can be used while the person's capable as well as incapable, the attorney should proceed on the assumption that the individual is capable of instructing them. But if they have reason to believe they're not, then they can start acting perhaps more and more, making decisions as to what they feel is best for the individual, as you know, rather than taking instructions. But it is very much a gray area. Now, and in that case, someone has to agree to a capacity assessment. So it's not possible to enforce a capacity assessment on someone.
Someone asked, wouldn't it be easier for a caregiver to set up the RDSP rather than a Henson trust?
So don't think of them as mutually exclusive. RDSPs serve a purpose, Henson trusts serve a purpose, and they should all work together and be considered. Often the best future plan for a loved one with a disability is having both. The nice thing about RDSPs is that, well, the government contributions, and any monies taken from the RDSP don't affect ODSP in any way. So it's a nice complement to the Henson Trust. But remember that an RDSP, generally speaking, is meant to be like a retirement savings plan. So, you know, payments would start later in life, whereas a Henson Trust, think of it more to replace, you know, while you're living, you're here to support your loved one in whatever way you like. The Henson Trust is meant to take the place of you once you're gone in providing that support.
So thank you so much, Natalie, for coming and for your wonderful presentation and for our participants for listening from across the province.